a post-conviction petition, usually where they're saying, did my trial counsel do well? That's a little bit more Monday morning quarterback, I think, because we're looking at what an attorney did and whether it was reasonable or not. And then
So there are a couple of different timelines of events that you'd have depending on what type of appeal it is. If it's a fast track appeal, which is for some of the more minor convictions that a defendant might have.
By the time your appeal is heard, you typically have already suffered all of the consequences of your conviction. And in order to get a stay of your sentence,
welcome, I'm Emily McFarling, and I am here with a panel to discuss criminal appeals. We're going to go over the nuts and bolts, practitioners' perspectives from both the defense and the state. Joining me today, I have Alexander Chen. He is the chief deputy at the District Attorney's Office and the head of the Appellate Division. Welcome, Alex.
Thank you. Thanks. Good to be here.
I also have with me Deborah Westbrook, who is a chief deputy at the Public Defender's Office and in the Appellate Division there. And finally, also with me, I have Amy Porray, who is the head of the Criminal Law Division at McFarling Law Group, Las Vegas criminal attorney. She practices appellate and district court work in family law and criminal law. Welcome, Deborah and Amy.
thank you.
Thanks so much.
Thank you for having us.
So we're going to start out with a discussion about who can appeal in criminal cases and what types of things the parties can appeal. Deborah, starting with you,
Yes.
What are the most common direct appeals filed by defendants in criminal cases?
Sure, thanks, Emily. So the most common appeal that you will see and that our office sees is a direct appeal from a judgment of conviction. And a judgment of conviction, that can follow a guilty plea agreement and a sentence from a guilty plea, or it can follow a jury trial. And our office handles both of those. Defendants can also appeal post-conviction proceedings. And that's something we'll talk about a little bit later. They can appeal from motions to correct illegal sentences and post-conviction habeas petitions.
And Alex, what are the most common appeals filed by the state in criminal cases?
Yeah, so the state's differently situated than most defendants. If a defendant wins at a jury trial, we can't appeal that conviction. So the times that the state really will appeal is if a judge, a lower court judge, either district court, sometimes justice court, makes a decision that's going to affect the outcome of the trial, or if they've dismissed a case, the state can file a direct appeal from that. If they've suppressed evidence, we can file a direct appeal of that to one of the upper courts. One of the other things that we'll oftentimes do is we file I wouldn't say oftentimes, but sometimes that we do, is we file a petition for writ of mandamus or prohibition. It's basically where we're asking the court to intervene and to review a lower court decision so that we can proceed to what we feel is a fair trial.
Excellent. And Amy, are there any other issues that are commonly appealed in criminal cases?
There are, and this applies only in death penalty cases. There is a saying in criminal law that death is different. And because of that, there is a lot of litigation in a death penalty case, and a lot more litigation than in criminal cases. So there is a special type of hearing in a death penalty case that occurs way before that case even goes to trial. And that is a situation when you have an intellectually disabled defendant, because under constitutional law, an intellectually disabled defendant cannot be executed. And so there's a hearing called an Atkins hearing. Atkins is the name of the case. It's a United States Supreme Court case that says that you cannot execute an intellectually disabled person. So what happens in this hearing is that it is the hearing to determine whether in fact this person is intellectually disabled. Following this hearing, in the event that the district court finds that the person is not intellectually disabled, then the defense can appeal that. It's a very important hearing. This is an incredibly important pretrial appeal, and you have an absolute statutory right to appeal it. So it's one of those very unique situations where you get a pretrial appeal.
Interesting. It's my understanding, Amy, that criminal defendants have a right to counsel at trial in Nevada. Do they also have a right to counsel on appeal?
They do, in fact. They have a constitutional right to counsel on appeal, and the case is Douglas versus California that says that when the state affords a right to counsel at trial, you also have a right to counsel on appeal.
And is that something that's specific to Nevada, or is it across the United States?
United States?
Criminal defendants have a Sixth Amendment right to represent themselves at trial under Feretta v. California. Can criminal defendants handle their own appeal?
They do not have the right to represent themselves on appeal. And here in Nevada, our case is called Blandino versus State. And our court says that there are reasons why the assistance of counsel is going to protect the appellate rights of a defendant, and it's going to assist the court in deciding their issues.
Interesting. Deborah, given that criminal defendants aren't allowed to handle their own direct appeals in Nevada, what legal obligations do trial attorneys have to ensure that their clients are taken care of on appeal?
Absolutely. So it's going to depend whether you are a defendant that has been convicted following a jury trial, or if you have been convicted following a guilty plea. And the obligations that counsel has to counsel a client is going to differ depending on which of those situations you find yourself in. So when a conviction is the result of a jury trial, the Lozada case in 1994 basically says that trial counsel has an affirmative duty to advise the defendant of the right to appeal, the procedures for that appeal, and the advantages and disadvantages of filing an appeal. However, if it is a conviction that results from a guilty plea agreement, trial counsel ordinarily has no duty to inform the client of the right to appeal. And that's generally because if you've agreed, you're typically not going to have a lot of appellate rights in those cases. Typically, the guilty plea agreement will contain language saying that you've given up pretty much all of your appellate rights except for some very limited things. So typically in those cases, you will have to only advise your client of the right to the appeal in the event that they express dissatisfaction or they are making inquiries about their right to appeal. So it's a little bit different in that circumstance. There's also a constitutional duty to file a direct appeal, and that arises in two separate circumstances. So when the client specifically requests that you file an appeal, as trial counsel, appellate counsel, you have an obligation. And then you also have the obligation to file the appeal when your client expresses dissatisfaction. That's also under the Totson versus State case. And so it's sort of different issues arise. How do you know whether your client has expressed dissatisfaction in a certain case? In Totson, the Supreme Court said that when the client's desire to challenge the conviction or sentence can reasonably be inferred from the totality of the circumstances, focusing on the information that counsel knew at the time, that is when there is that dissatisfaction, and it differs somewhat, in the context of a direct appeal from a jury trial. In most cases, it'll be more obvious that if somebody is upset that an appeal should be filed. But if it's in the context of a guilty plea agreement, you look at things like, did the client, was there an outburst at sentencing? Did the client appear like they were really, really upset? You look at things like, did the client receive the sentence that they bargained for at the time of, sentencing? Was it what they expected? And if it wasn't what they expected, then maybe there's, more of a likelihood that individual, wants the appeal. So you look at all those things.
Interesting. Alex, are appeals from misdemeanor convictions in justice court and municipal court handled differently from felony convictions in district court?
Yes, they are, Emily. So a misdemeanor conviction, which is either obtained in justice court or in a municipal court, the appellate court for that is going to be a district court judge. Whereas if you get convicted of a felony, then the Court of Appeals or the Supreme Court, depending on the level of category of felony, is going to be the reviewing court. So there are going to be different rules that apply to this. NRS, I believe 189, Chapter 189, is going to deal with misdemeanor appeals. It has to be filed within 10 days of the conviction, which is shorter than a felony appeal. Felony appeals, you have to file your notice within 30 days. So there are different requirements there. And different reviewing courts. Now, there are certain exceptions. If I believe certain constitutional implications are raised, then one of the appellate courts could actually review a district court finding on appeal. But generally speaking, the district court is going to be the last court that reviews any type of misdemeanor conviction.
If you have a misdemeanor and you appeal it up to the district court, it ends there, or can you then go up to the Court of Appeals in Nevada Supreme Court if you're not happy with the district court decision?
Generally, it's going to end there unless you can raise an issue where the court feels that it should entertain it. So usually that's going to be a constitutional issue where they feel that they should entertain something on appeal. One of the examples here was, I believe, like Anderson, where we started giving jury trials for misdemeanor domestic violence convictions. So that was something that came from the Nevada Supreme Court, not just the district court opinion. So there are certain instances, but usually the court gets to decide when they want to actually hear that.
Interesting. And is that in felony conviction appeals, does the Supreme Court or Court of Appeals have that discretion to, decide what they get to hear or not hear?
Well, the statute does list what rights a defendant has to file an appeal. So the appeals are generally from the judgment of conviction. That's when they actually get to file appeal. Based upon either the issue or the category, it'll get routed to either the Court of Appeals or to the Nevada Supreme Court. But they are specified by statute which times they're able to actually file an appeal.
Sorry to interrupt, and we're going to talk about stays in a minute, but because Alex is talking about the misdemeanor appeals, what I think is really interesting about those is that the procedure for a stay in misdemeanors, it's a little bit different than when we talk about stays in felony appeals. Because when you do these misdemeanor appeals, someone is already sentenced and sentenced immediately, which is similar to our felony appeals. But in the majority of misdemeanors, people do some requirements. And by requirements, I mean pay a fine, take a class, have a suspended jail sentence. These things happen very quickly compared to prison sentences, probation. So it's been this interesting thing for me, and I think this is maybe a policy consideration. But when you want to appeal, say, a domestic violence conviction, driving under the influence conviction, at the same time your appeal is processing through in district court, which becomes lengthy, you're still having to do a DUI class, pay a fine, do your community service. By the time your appeal is heard, you typically have already suffered all of the consequences of your conviction. And in order to get a stay of your sentence, courts typically require an enormous posting of a bond. Usually the maximum amount of the fine is in my experience. So say you have to post a $2,000 bond to stay your sentence. Most people can't afford that, and so it's this very strange thing I find on these misdemeanor appeals. Just wanted to kind of, and we're going to talk about stays, but just jump in on the practicalities of what I see as maybe it's not a non-existent right to an appeal, because you still could have your conviction overturned, but it would then be remanded back for a new trial.
Is it less common for misdemeanors to be appealed because the consequences often have already happened by the time the appeal finishes?
I've only done a very few misdemeanor appeals. I think in battery domestic violence cases, appeals become more critical, and that's because you lose your Second Amendment rights. With a battery domestic violence conviction, you can no longer carry a firearm. And so that conviction is, whether you're doing your classes or not, that becomes something that is very critical. Or if you have immigration consequences, appeals from, depending on what the misdemeanor is, there are some very, very impactful consequences on if you have a lawful permanent resident or whatever type of immigration consequences there may be. But otherwise, I think it is a hindrance really to appealing. And that is one area, although people may think, well, it's just a misdemeanor, I think the chilling effect on an appeal because of the way that the courts handle the staying effect of your sentencing requirements is something just, I'm ruminating on policy, but it's something that I found this kind of dichotomy of two things going on.
Interesting. Let's move on to talk about the process for a defendant to directly appeal a judgment of conviction from district court to the Supreme Court. Amy, how does a defendant initiate an appeal?
An appeal is initiated by filing a notice of appeal in the district court following the entry of the judgment of conviction, except for when you have a death penalty appeal, and that's automatic. It has to happen.
And what is the deadline for filing an appeal to the Supreme Court?
It's 30 days following entry of the judgment of conviction, and that is a hard and fast rule.
And can that deadline be told?
It can be told by filing a motion for a new trial.
And what happens if you file your appeal before a judgment is entered?
It gets treated as starting after the judgment of conviction gets entered. So it's not like it's precluded or you're untimely or anything like that.
So they just keep the appeal in place and then,
Yeah.
fix the timing issues after it's filed?
Better early than late.
Yes. And Deb, what happens after you file your notice of appeal? What's the timeline of events?
So there are a couple of different timelines of events that you'd have depending on what type of appeal it is. If it's a fast track appeal, which is for some of the more minor convictions that a defendant might have, so like a C, D, and E felony, if it's one of those, then it would go into the fast track system. We're not going to really talk much about the fast track system today because actually it turns out not a lot of cases go into fast track. These are, it's sort of rare. We spoke with the clerk at the Supreme Court, and not many of those cases are filed at all. So I think the focus that I want to take today is on the direct appeal in general cases. So typically, what happens? The case is first docketed in the Nevada Supreme Court. So after the notice of appeal is filed in the district court, it takes a few days, sometimes maybe a week, and then it'll get docketed in the Supreme Court. And that date triggers all of the filing deadlines that kind of follow after that. So when the case is docketed, the Supreme Court will mail out a couple of things to the practitioner, to the appellant, and there will be a docketing statement, which is a form that contains a bunch of information that will help the district or the Supreme Court clerk process where the case goes, determine whether is this a case that is likely going to be retained by the Supreme Court or sent down to the Court of Appeals. It has information on it about the timing of the case. So they'll ask you a question like, when was the judgment of conviction filed and when was the notice of appeal filed? And if you're outside of the 30-day deadline, then that flags for the clerks that the case, the court might not have jurisdiction for the case. And then in that sort of situation, they might send the party an order to show cause why the case shouldn't be dismissed. So those are the types of things that are on the docketing statement that you get from the court. Within 14 days after the case has been docketed, the transcripts have to be requested. So the parties, the appellant, will need to know kind of what transcripts they want to have requested from the district court, depending on what type of appeal it is. If it's an appeal from a full trial, then you're going to want to, of course, request all of the transcripts from the trial and everything. But if it's just maybe a sentencing issue, then you would be just requesting the transcripts from the sentencing. The next deadline that comes after that is the docketing statement. So that form that the Supreme Court sent you at the very beginning when it was docketed, the parties will fill that out, the appellant would fill that out, send that back. And then you have within 120 days of the docketing is when the opening brief is due and when appellant's appendix is due. And we'll probably talk a little more about the appendix later, but it's essentially all of the documents from the trial or from whatever proceedings you are challenging. When you are presenting your arguments in your opening brief, you need to support them with the information that's in the appendix. So those two things are due within 120 days. 30 days later, the respondent's answering brief is due, and then 30 days after that, appellant's reply brief is due. And I should clarify that these deadlines are for non-death penalty cases. These are for just standard appeals. There's a different, slightly different briefing schedule that applies in death penalty cases.
And you were talking about the appendix. Can When the Supreme Court or the Court of Appeals is reviewing an appeal, can they look at any information that someone wants to submit in their appendix, or is there rules that limit the scope of what you can put in for the review?
That's a great question, and yes, so the appendix is going to contain items that were in the trial court record. So it's things that were actually filed with the court, things that were actually presented to the court, transcripts of the proceedings. If it basically wasn't said in court, if it wasn't presented to the court, that's not something that can be included in the appendix for consideration on appeal.
And so that would exclude anything that happens after the judgment of conviction or after the district court case as well?
Not necessarily, because after the judgment of conviction, you might have a motion to correct an illegal sentence, or you might have a motion for a new trial based on newly discovered evidence, and those things also can be added to the appendix afterwards. I've had cases where we've discovered while I had a case pending that there was an issue that hadn't been presented to the court, so we did a motion for a new trial based on newly discovered evidence. That was subsequent to the appeal being docketed, and we ended up consolidating those two cases. I appealed from the other order as well, and it was all, the Supreme Court considered all of it in kind of packaged together.
Interesting. And this briefing schedule that gets set in place, are you able to get extensions to it? How fixed is it?
Yes. So thankfully, yes, you are able to get extensions, and as any appellate attorney knows, extensions can kind of they're very necessary at times. So after you can get them after the appeal is docketed, but you can't get them before, obviously, because you can't extend that deadline, that 30-day deadline for filing the notice of appeal. That's jurisdictional. So right now, you can't get an extension before the appeal is docketed, but once it's docketed, once it's up at the Supreme Court, every party gets one 14-day telephonic extension, kind of no questions asked. You call the court and you say, hey, I need the extension, and they give it to you. Alternately, the parties can do what's known as a 30-day stip, and when you have opposing counsel that's as nice as Alex Chen here, we don't have any like real challenges to that. They always agree to ours, we always agree to theirs. So that's another thing you can do, and that's only in non-capital cases. I'm not sure why capital cases you don't get that stip, but maybe that's a question to ask some folks up at the Supreme Court. The parties can also file a motion on or before the date that the brief is due. So let's say you got your 14-day telephonic, and you realize afterwards, oh no, there was all this other stuff I don't have, the transcripts aren't ready yet, or I need to go to the evidence vault and pick up some evidence that I don't have. So you can put that into a motion that you file on or before the date that the brief is due, and then you ask them and explain why an extension is necessary. And if it's your second or subsequent request, you have to show extreme need and you basically have to have a heightened burden. It's not just good cause. You have to give them kind of a little bit more, and ordinarily counsel's caseload will not be considered good cause under the current rules. So you're not guaranteed, certainly, whether you want an extension, you're not guaranteed to get one, and sometimes it depends on who the presiding Chief Justice is at the time. But yeah, they're definitely available if needed.
And Amy, what issues can or cannot be raised in a direct appeal from a judgment of conviction?
So from a judgment of conviction, you can raise certainly the verdict, when I mean verdict, I mean trial issues. You can raise what happened at trial, you can challenge, the conviction, and you can challenge any pretrial orders. What you cannot raise are things that your attorney did wrong, and that means you can't say that your attorney didn't handle things the right way, that your dissatisfaction, and when I say your, I mean the defendant's dissatisfaction with their trial counsel. Those are things for later in post-conviction proceedings.
And so a direct appeal would be looking at the decisions a judge made, not the decisions or actions of the trial counsel?
Correct.
And Deborah, what steps should an appellate attorney take when they get assigned a new case?
Great question, and I can I speak to my own practices. What I do in the cases that I have. The first thing that I always want to do is reach out to trial counsel, because I'm appellate counsel. I wasn't there at the trial. I don't know what happened, and the best resource for information about issues in the case, you want to reach out to trial counsel, find out were there issues that they felt were very serious. If they made a motion for a mistrial at some point, they'll be able to tell me that right off the bat and let me know kind of what the serious issues are. It's also good to do that before you speak to the client, before you consult with the client, because the client is going to want to know that you know something about the case before you speak with them. You don't want to go in and kind of be like, yeah, I don't. What's going on? That's not a good way to establish rapport with your client on appeal. So after I've spoken to trial counsel, I will generally send an intro letter, because my clients are, for the most part, going to be in NDOC custody at one of the prisons in the state of Nevada. So I send them an intro letter. I let them know who I am. I give them kind of a heads up on what the typical deadlines are, the timeline for an appeal. So they sort of have a sense for, this isn't something that's going to be resolved super quickly. This is, they kind of can understand that an appeal takes a while. And I encourage them to reach out to me, because they're going to have to give me a call. So for attorneys in the public defender's office, we accept direct billed calls from prison. And I know like a lot of, maybe if the attorneys that are working in private practice, they may not be able to accept direct billed calls. So in certain instances, I've had clients tell me that they haven't been able to get, if they have a private attorney, they can't reach them, they can't contact them. So that's going to be really important. If you have clients that are in the prison, they need to be able to reach out to you. There needs to be some mechanism for you to be able to get those calls. So after I've had a chance to kind of send that initial information out, I get copies of everything that was filed in the district court docket, like all the briefs, all the orders. I have we'll print out, the docket itself that lists everything that kind of goes that was filed in the case, that was discussed in the case, and then you want to make sure that you're getting all the minute orders. You're going to the evidence vault and you're requesting all of the evidence if it was a trial, as opposed to like a sentencing issue. You make sure you go to the evidence vault and you get copies of all the evidence so that you can see what it was that the jury looked at. Perhaps you have an issue involving closing arguments. You want to see if PowerPoint presentations were shown to the jury. You want to make sure you have a chance to look at those so you can see if anything prejudicial might have been shown. You really want to have sort of the entire universe of things that the jury saw and be able to look at all that so that you can assess whether or not there was an error or whether there was something at issue. So our office typically, and this is probably not the case elsewhere. Our clerks will put together the appendix for us. So I will instruct the appellate secretary and the clerks to get everything, put it all in the appendix, and then they will put that appendix together, and I will begin my review of the case once I get the appendix, because it's all in order. It's got all the Bates stamp numbers on it. And once I have that, that's when I start doing my analysis of the case, and I will create an outline of the appendix so that it ties to the timeline, and then I have the Bates stamp numbers so that I can take my outline of everything that happened in the case, and then I can plug it into a brief later. And it makes it so that you don't have to go back and you don't have to be thumbing through the brief or thumbing through the appendix the entire time. You'll sort of get your outline of the issues, what the witnesses testified to, flagging areas where objections were made. Then you'll want to create a second outline of issues as you're going through and looking to see where there might be issues that you can raise on appeal. One of the things that I neglected to mention, actually, and the first thing that I do before I start reviewing the appendix is I pull all the statutes from the crimes that the client has been convicted of, so that I know what elements needed to be proven. And that way, when I go through the record, I can see if there was, maybe a failure to prove something. And it also helps when you're evaluating jury instruction to make sure that the jury instructions are tailored to the elements of the crime. If there, sometimes there could be errors there. So you want to make sure that you know the charges, the law. If it's maybe it's an appeal you get that isn't one that you're familiar with, that it's a crime that you haven't really had a chance to look at yet. You want to make sure you kind of do your research on the front end. That way, when you're going through and you're analyzing the record, you're able to spot all of the issues. And then, when I am looking through the the appendix, I'm paying close attention to jury selection. I'm paying close attention to if there were any mistrial requests. I'm paying a close attention to closing arguments, sentencings, and then for purposes of sentencing, you want to compare the judgment of conviction with what was said at the sentencing hearing to see if there are maybe discrepancies there. So there are a lot of sort of things that you have to keep in mind as you're going through and analyzing the record. And those are the things that you do before you write your brief, essentially.
I was going to ask if I can jump in.
Yeah.
I was going to ask, as a defense attorney, do you keep a list kind of issues that you look for in every case? Like you were talking about, you look at closing arguments, certainly for prosecutorial misconduct, and then you're looking at things that happen when you pick a jury. There are kind of standard issues, like you were saying, every time a mistrial is asked for. Do you keep a list of those as well?
So I don't. I mean, that would be on my issue list.
Yeah.
So it's more like as I go through, I know I've been doing it long enough that I know what issues or what areas are sort of fertile for appellate, argument. So I make sure I have that outline though, of a running outline of everything that I see that's like, ooh, this could be a problem, this could be a problem, this could be a problem. And then when I'm looking at whether or not these are harmful errors or not, you got to go to the closing argument to really see how did that evidence that you're arguing shouldn't have come in, how did it affect the trial? Maybe it didn't affect the trial, and that tells you whether or not it's an issue that's important to raise, because once you are sitting down to write your brief, you have to kind of whittle it down to the issues that are going to be able to fit in your 14,000 word brief. So you got to be able to prioritize.
You were talking about how you review the record for certain issues, and as an appellate attorney, and all three of you as practicing appellate attorneys, you must have a list of issues that you keep in your head and knowledge or a way of thinking that you have to review cases. Do you think that the skill of being an appellate attorney is a different skill than being a trial attorney, and what you have to be looking at or knowing what to do as a trial attorney? Absolutely, yeah. I mean, it is completely different. I mean, as a trial attorney, you're mainly wanting to win the case. Thinking perhaps of preserving issues as sort of secondary, but as an appellate attorney, you're going through there and you're really trying to figure out, if there's a basis for reversal, you're looking for whether they have objected, properly and preserved the issue. And, if they didn't, you realize, I could have a great issue, but they didn't object. So the odds are I'm not going to get a reversal on this because I'm not going to be able to show the, the sufficient prejudice to the client. So it really, you have to have a lot of those are all the things that you'll have in your head as an appellate attorney that, probably, it's a sort of a different way of looking at the case than I think that trial attorneys would look at it.
Can I jump in with one more? Sorry. Yeah. I was wondering, Alex, how do you, as the state, do you have your set of issues kind of, or, because I know you're defending against, but do you have a way of responding to things that is, I don't want to say stock, but kind of there are certain things that are stock because there are certain things that are, say, structural to each trial and certain things that are going to apply in each trial. So does the state have a similar way of working each brief?
I would say it depends on the type of appeal. So we deal with the appeals from a judgment of conviction that you mentioned, and then we also deal with those appeals from a post-conviction petition, usually where they're saying, did my trial counsel do well? That's a little bit more Monday morning quarterback, I think, because we're looking at what an attorney did and whether it was reasonable or not, and then we're looking at whether it would have affected the outcome or not. So that's a little bit more stock in terms of post-conviction appeals. We look at the formula. Okay, maybe there could have been more that was done, but was it within the realm of reasonableness? When we come to the direct appeals from a judgment of conviction, as you know, those topics can really be varied. It could be anything. It could be the jury that came in. It could be a motion that was made mid-trial. It could be something that a witness said. So there we really just try to see whether, all right, what they're raising, is that an actual error or not? Or do we see that as an error? And sometimes we actually do. There are times that we've spoken and we said, I think this was wrong. But would that have affected the outcome? Right. What is our approach going to be to it? So, for instance, we both worked on something recently where 75% of our brief was actually very similar when it came to what we thought about what their answer was. But occasionally we might come to a different result, or we put a different emphasis on what impact did that have on the trial. So that's basically the route that we take, or the process that we look at our appeals.
And I think for you, because you're respondent in so many of these cases, you know, you really just have to look at our brief to see what we filed, and then answer, you know, and kind of like directly look at those things. There's less scouring the record to find issues.
Yeah, that's definitely true. That's very different between us and the defense appeals.
And so, Alex, what do you do when you review an opening brief from an appellant and you read it and you say, oh, that was a mistake, that was wrong? What do you do?
Well, it depends. There are times where I think our briefs have actually conceded that this was error. And depending on the amount of error, we do different things. We might talk to defense counsel and say, hey, we recognize this could be an issue. Where do we go from here? Is there something that we can agree what the result should be? So we've actually tried to correct it, because even though there's an error, sometimes it doesn't mean that the whole case was false necessarily. That depends on the facts. But there might be something that we're at least concerned about. And so we might have a dialogue about where we're going to go from there to avoid that particular issue. And sometimes we litigate it. So it really depends. But there are times that we've recognized that judges perhaps have done something that might not have been the best thing for the appeal later.
Interesting. Deborah, how do you know whether a case is going to be heard by the Nevada Supreme Court or the Nevada Court of Appeals?
Great question. So NRAP 17 is the rule of appellate procedure that governs the routing of cases between the Supreme Court and Court of Appeals. The way the Court of Appeals operates, it's a push-down model. So the Supreme Court, every case that is filed, every appeal that is filed goes initially to the Supreme Court, and then they will send cases down to the Court of Appeals based on the contents of what's known as the routing statement. There's information also in the docketing statement about the routing as well. So there's two places where parties would provide information to the Supreme Court as to where the case should be assigned. So there's a sort of a general rule of thumb for criminal cases. If it's a death penalty case, those automatically always will stay at the Nevada Supreme Court. If it is, other types of criminal appeals, there are several types that are presumptively assigned to the Court of Appeals, and those are listed in Rule 17. So we've got guilty plea appeals, because they're generally routine. The same issues are involved in most of those cases. Those are presumptively assigned to the Court of Appeals. Appeals from jury verdicts that don't involve A or B felonies are also presumptively assigned to the Court of Appeals. And when I say presumptively, that's sort of the general rule of thumb that they get assigned there. It doesn't guarantee that they will be assigned to the Court of Appeals, but that's typically where they will go. Appeals that challenge only sufficiency of the evidence. I mean, that's a pretty high burden. If you're challenging sufficiency of the evidence, generally there's a presumption that you view the facts in the light most favorable to the prosecution, and you kind of give the jury the benefit of the doubt in those cases. Since those are pretty simple to resolve, those go to the Court of Appeals presumptively. Appeals, post-conviction appeals that challenge a judgment of conviction or sentence that are not Category A, those presumptively go to the Court of Appeals. as do post-conviction appeals that involve computation of time challenges, time served, motions to correct a legal sentence, and motions to modify a sentence. Now, there are ways that, let's say you're in one of those areas that would be presumptively assigned to the Court of Appeals, or maybe you have a criminal case that doesn't fall into either presumptive assignment or that doesn't fall into mandatory assignment. If you can show that your case involves a novel legal issue, so questions of first impression, something that's really important, statewide public importance, or if you can show that you've got an issue that involves an inconsistency in decisions of the Court of Appeals that conflict with one another, or the Supreme Court that conflict with one another, and you can present that to the Supreme Court in your routing statement and in your docketing statement, the Supreme Court may retain those. And they actually right now, like if you can actually show it, that's mandatory assignment to the Supreme Court. So there are various ways that the case can be routed, and as you're looking at your record, you can kind of get a sense for if you think you've got some novel issues, maybe it goes to the Supreme Court.
Maybe what are the different types of error that would be brought up in appeal, and how do they affect the outcome of a criminal case?
So there's structural error. And structural error is something that you say infects the whole proceeding. Structural error is an error that is incredibly important, because if it infects the whole proceeding, that means that the case must be reversed and go back for a new trial, because you can't trust what happened in it. And this is kind of my, just breaking it down, not giving kind of the legal terminology, but that's basically what it is. And there are very few of those that are outlined kind of in our constitutional law. So that's a very important one. And it's something that, Deb, I know you'd agree, we look for in every single case when you're doing an appeal, every single case. And then there's harmless error. And harmless error is an error that occurred that was, as it says, harmless to the proceeding. So if it's found to be harmless, then it's not an error that is going to affect the judgment at all. And that is what Alex is going to be arguing, that any error is harmless. And then there's plain error. And plain error is an error that was not preserved below. So if there is something that happened below and that the error was not preserved, that it is so plain that you can see that regardless of the fact that somebody didn't object to something or that something wasn't done to otherwise save that for appeal, it was so plain that it infected the proceedings and that it is still considered error. And if it's so plain, it could result in a reversal of the trial and come back for a new trial.
Interesting. Alex, what are common mistakes that you see defense attorneys making in their cases?
They're perfect. I guess what I would say is that when we're reviewing something that an attorney has done down below, I just think it's important that anyone who's going to take on defense work and anyone who's going to especially go to a trial for a defendant's case quite honestly knows what they're doing and has consulted, at least, they might be a great person in trial, but have they consulted with other people who might have had more trial experience just to make sure that they're crossing their T's, dotting their I's. And not only is it the defendant's liberty that's at stake and their reputation that's at stake, but it's the attorney as well. The defense attorney, at some point, if their client gets convicted, is probably going to be held accountable through a petition for writ of habeas corpus. They're going to have a talented attorney, is one of the ones sitting to my right here, challenging the type of work that they've done. And not only is that going to impact the defendant, it impacts the state's case because we might have to do it over again, but it also could mean that a reviewing court reviews that attorney's work and says, wow, we can't believe how poorly this attorney did. And there's a term we use, ineffective assistance of counsel, but that lives on forever. I mean, that's in a case. Sometimes they get named if it's especially egregious. So that's something that I think is important for any practitioner that's doing defense work to really take that seriously. And I would say the same thing for their appeals as well. When we're reviewing an appeal, defendants have the right to effective appellate counsel, just like they have the right to effective trial counsel. We want to see good appeals so that we can respond to them appropriately as well. And that means going through the record, citing to the record, knowing the rules of an appeal. So talking to people and reviewing the rules to make sure that you're in compliance so that the person isn't impacted negatively is super important. And I think it's important for all people to always consult with others to make sure that the best product is getting put forward.
So Alex, I'm curious to know, when you look at appellate briefs that you've received from defense attorneys, are there things that that kind of stand out to you that maybe happen a bunch, like maybe not citing the record? Like where are areas that you see kind of the most mistakes happening in the appellate briefs?
Citing to the record is probably one of the main things. That there's the appendix that you mentioned, and you have to cite to the appendix if you're going to cite to a proposition. The other thing that we oftentimes see is new issues that are raised in reply briefs. So the appellant files their brief, we respond, and then all of a sudden you're raising a new issue, or they're raising a new issue. And oftentimes the court will be quick to say, that's not something that we're going to consider because you could have raised it in your opening brief. So that's one of the things that we see. Not frequently, but at least for people, especially who aren't super used to doing appeals, we'll see that happen from time to time.
Interesting. What happens after briefing is done? How long does it take for there to be a decision in an appeal case?
So as far as timing, it takes a while is the best answer I can give. It just depends. After your briefing is submitted, your case will be assigned to either the Supreme Court or the Court of Appeals. And you kind of know is the other answer that I can give. So there's some way of knowing, and Deb talked about the routing statement, but you can't say for sure where it's going to go. It will either be submitted on the briefs, and that means that the court will just read the briefs without hearing oral argument. So in that way, it's different from any of trial court practice, where in large part, briefs, all of your briefing is heard by oral argument. There's rare exception, and that occurs more in, say, our family cases, where the court will consider something without hearing argument. In criminal, typically everything is done by argument in court. Or in rare situations, then the courts will schedule oral argument on your briefs. It's very different argument than down in the trial court. It's very formal. There are rules of arguing, and the court will issue and set your case for oral argument. In that type of oral argument, there are timing. Each side has a specific amount of time. You are questioned by the entire panel, whomever is sitting, or the court en banc. It's a very formal process. The other thing that can happen is if the case is sitting for a long time, you can file supplemental briefing if, say, a new decision comes out that has a direct impact on your case. Or there are instances where the court may direct supplemental briefing. If the court finds that something needs to be more fleshed out, or if the court finds that there's new case law that would help assist in its decision. And that kind of gives you an idea of where it may be going. And that's basically the process.
In the family court appeals that I do, as soon as briefing is completed, we usually get a notice if it's going to be assigned to the Court of Appeals, saying that it's been assigned to the Court of Appeals, or we don't get one and it stays. Is that the same in criminal appeals?
You'll get a notification. They'll email it to you, and you'll find out that it's been assigned. And generally, when it's been assigned to the Court of Appeals resolves cases pretty quickly. Once it's been assigned, most of the cases that go down to the Court of Appeals are resolved within 6 months.
But I would say you won't always know when you submit your brief. So sometimes the briefing does get submitted early to the Supreme Court, and then it gets transferred to the Court of Appeals, and they'll have an entry for it. Other times you already know, okay, I'm going to be with the Court of Appeals, or I'm going to be with the Supreme Court, and that's who's going to make the decision.
And Amy, what are the different types of outcomes that can happen as a result of an appeal?
So the judgment of conviction can be affirmed, and that means that there is no relief from the judgment, it's just upheld. It can be reversed, meaning that it comes back for a new trial. They reverse what happened at trial and the jury's decision. It can be affirmed in part and reversed in part, meaning, say, if you have multiple counts, meaning multiple charges at trial, some can be upheld, some can be reversed, and then you go back for a new trial only on those that it found reversible. The jury's verdict can be vacated, and that's in the sufficiency of the evidence context, That is so rare. So rare. I think I have only ever seen, I can think of maybe like one case on sufficiency. Can you think of a lot of sufficiency?
Not a lot. I mean, it does happen occasionally, and usually it'll be like on one count. You might have, I've had cases where there are very serious counts, and then those are upheld, but then maybe something minor that the Supreme Court might say, there was insufficient on like a weapons possession count or something, and then the case, so if it goes back on retrial for that, if it's found to be insufficient, you can't retry them on that count.
Exactly.
Okay, so if it's reversed, you go back for a new trial, but if it's vacated, that's it, you're done, that criminal charge goes away.
Yeah, it goes away. And so I was just thinking about one case, in fact, that I had. It was so long ago that happened. And actually, the sentencing judge was really smart and ran the ones that became vacated. The sentence was concurrent with the ones that were affirmed. So we already prepared for that situation.
Yep.
So, there you go.
And so, Deb, if a client's convictions are reversed and the case is remanded for a new trial, does that mean that your client gets to automatically leave custody?
They would all love this, but no, because if there's going to be a new trial, there potentially the bail issues would be at issue. So they might need to be in custody after that. But typically what happens when the case is reversed, the NDOC doesn't know for sure whether the case, whether your client can go free. So NDOC is going to keep them in custody until they receive a document from the Nevada Supreme Court. It has to be like a certified from the clerk telling them that the judgment has been reversed. And it's generally, you're not going to be able to get that document right away because there are, you have to wait for the Remediator, first of all, which we'll talk about in a little bit. But the decision doesn't become final until after that Remediator is issued, and then you have to have that official stamped copy going to NDOC. If they don't have that, they're not going to let your client out. And so I've had clients that some of them want to stay in NDOC custody, and so we won't maybe try and get that documentation sent to Nevada Department of Corrections. But then you have other clients that potentially, they would like to go down to CCDC, to the Clark County Detention Center, because maybe their families are closer. So, and for those clients, you definitely will need to ask the Supreme Court clerk to send that information over to the Nevada Department of Corrections so that they will know, so that it can facilitate the transfer of your client. But ordinarily, unless you do something, they're most likely just going to stay there. So an additional step has to be taken by the attorney.
Interesting. And what options does a defendant have after the court issues a decision affirming his or her conviction or sentence?
Yeah, so it's not totally the end of the road if you're a client and your convictions have been affirmed. There are several options. I mean, they're not all. They're sort of long shots, but you have the option of filing a petition for rehearing. That's the first thing. If it was a panel decision or en banc, and that petition for rehearing, you have to file that within 18 days, and you're essentially telling the court, please look at this again. And you can only do that type of filing if they've overlooked or misapprehended a material fact in the case. So there was something in your brief that they didn't consider, or if there's overlooking or misapprehending a material aspect of the law. so if it's really more for kind of error correction if they missed something, and typically those are not, you don't typically prevail on those because the panel has already heard the case, and that one's going to be a bit of an uphill battle. You'll have more of a shot at seeking en banc reconsideration, and unfortunately, to get to en banc reconsideration now, the way the rules are set up, you have to first do your petition for rehearing. So you might not have like a great argument on petition for rehearing, so that takes 18 days. Then you have to wait a couple of weeks for the court to say, no, you don't have any good issues. So then they'll shut it down. Then you'll have 14 days from that point to argue that the entire court should consider it. So and this is an option for cases where you've had a panel decision. It doesn't work if you already had an en banc. If it was already en banc, this option is not available to you. But essentially, if you can show the court that maybe there is a conflict, the decision of the panel conflicts with another panel decision, or it conflicts with an en banc decision, or if you can show them that there is an issue of substantial precedent that the whole court needs to look at, it's of statewide public importance, constitutional or policy issues, things that are really, really weighty and really meaty issues that the whole court might want to address, then you can get en banc reconsideration. And typically what happens after that, you file your brief. If you don't have a great issue, a great presentation, usually these are resolved within a couple weeks. Like you'll get a notice that says, petition denied. Or if you're lucky, they'll direct briefing from the other side and order them to respond, and it can take a little while. The other option you have, like let's say you're in the Court of Appeals and you don't like the way that issue has come out, you'll have 18 days to file a petition for review with the Supreme Court, and then you're again trying to point to issues of conflicts between the decision of the Court of Appeals and maybe a Supreme Court decision. You're looking at again issues of first impression, things that are important, things that the whole court would want to weigh in on. So, and then if all else fails, if you're denied at that level, you can petition for certiorari to the United States Supreme Court, which is a complete like Hail Mary. I've filed several of these, and they typically don't take cases from state courts. So those are the options that you have, directly after you lose your appeal.
And then you mentioned earlier a remediator. Amy, what is a remediator, and how does it affect a case?
The remediator is the document that, after the court's decision, sends the case back and gives jurisdiction back to the district court for any proceedings that need to come after the decision.
Okay. Can anything happen in the district court prior to that remediator?
No.
And is there a time period that it takes for an appeal to get to the point that there's a remediator?
You mean from beginning to end?
No,
Sorry.
no, from the point of the decision. Is a remediator issued within a certain time period after the decision?
I think it's isn't it 25 days?
I think it's around 30 or
Yeah, I was
so.
going to say usually 30 is
Probably after the time periods to do other
Yeah.
type of action challenging the decision have run.
Yeah.
Exactly.
What are the client's next steps if they lose their direct appeal and the court denied rehearing or en banc review?
So at that point, then they can move to the post-conviction proceedings. And they do this now. They do not have a right to counsel on post-conviction. They can ask the district court to appoint them counsel on post-conviction. That is typically denied, except for in cases of the most serious convictions. And by most serious, Deb was talking about A and B felonies. Felonies are classified by a letter. A felonies are the most serious of felonies. That includes things like murder, sexual assault, kidnapping. When there are convictions from complex cases or serious felonies where people are serving incredible amounts of time, hundreds of years or like that, then courts are likely to look at those cases as granting counsel. But that's where they move to post-conviction proceedings and say, I was not given effective assistance of counsel either at trial or on appeal. They have to do this and file within 1 year of the judgment of conviction, and those proceedings begin. And this is the time where there's exhaustion, it's called exhaustion. And so if they're going to move over to the federal court system, and this is especially important in capital proceedings, because capital proceedings go on and on until a point of execution. And so post-conviction proceedings begin here and then move over to the federal court. Also it's very common in murder cases, sexual assault cases, that you look to post-conviction proceedings, and then they move over into federal court, into the federal public defender's office for both capital and non-capital habeas. And so that's the next step in the next course.
And so earlier we talked about how you can't file an appeal without an attorney. For the types of cases where a person filing a post-conviction relief claim is not entitled to an attorney, are they required to hire an attorney in order to file those proceedings?
No, they do that on their own. They can proceed on their own. And they file that. They are able to then, they get their file from their previous attorney, whomever handled their trial and their appeal, but they can move forward and do these proceedings on their own.
Yeah, I mean, Alex, you're responding to a lot of these when the court directs you to.
Yeah. So even if a person has requested counsel for their first post-conviction petition and that's denied, they can still file an appeal, and it goes to either Court of Appeals or Supreme Court. And then sometimes we will get an order back saying, district court erred, you need to provide this person an attorney, and then that attorney can file a supplemental petition on their behalf. So even if in the first instance they weren't given an attorney, sometimes the courts do come back and grant them that right.
And so how often do you get cases filed by people seeking post-conviction relief without an attorney representing them?
Well, most of the times they will file, the individual will file their own what we call a bare bones petition, or just a basic filing, and oftentimes in that same filing they'll say, I need an attorney because, and it could be because I don't speak English, it could be because I'm not very sophisticated, I don't understand the law. And then there was a case, I believe it's Renteria Nova,
Yep.
where they basically go through the factors and they say, what's the sentence, what's the difficulty, what are they challenging? So there does need to be some indication in their pro per filing of why an attorney is needed, but then the court makes their decision based upon that.
And usually, I think, if correct me if I'm wrong, but typically when a client who is unrepresented and then they decide that they want to appeal a decision, they'll file their notice of appeal, but then the district court will just send up the entire record to the Supreme Court, and they won't be filing any appellate briefing. There's usually they just have the entire record that the court looks at. Is that
something I learned more recently?
Yes.
But yes, that does happen. There are times where pro per individuals will also file an actual appeal with the upper court, and it's up to the court to determine whether we have to respond to that or not. So it's not automatic, like if one of these two file one, then we actually have to respond to it. But if it's one of these pro per filings, there's some discretion that the court utilizes to order us to respond. Interesting.
Let's talk about common appeals by the state.
Okay. So one thing I mentioned before, we only appeal certain things. We appeal if potentially a case has been dismissed by the lower court, whether it's the justice court or the district court. So if the case has been dismissed, we have a right to appeal. We do what we also call this common term, the petition for writ of habeas corpus. Sometimes, the petition of writ of mandamus will file saying that the court got it wrong. So that could be based on a number of things. It might just be that we've lost some counts in a case. So we got to keep some counts, but they dismissed some counts. We could appeal that. It could be they dismissed the whole case. We could appeal that. In one case I'm thinking of, the court prohibited our witnesses from testifying based upon a notice issue. We filed a petition for that, so not an appeal, but a petition, and the court did entertain briefing, but then we ended up losing that. So those are some things that we do. The other times, it's not really an appeal, but I think it's significant in terms of the work that we do, is we can sometimes seek either rehearings on matters from the Supreme Court of Appeals or Supreme Court, and that's asking them to clarify certain laws. So, for instance, some of the work that we've done together again was where we thought that there was a discrepancy in the law and we wanted some type of clarification for it. So we filed either a petition or a review asking the court to entertain it and asking the Supreme Court to review the Court of Appeals and tell us what the legal answer in Nevada is. So that's another thing. It's not quite an appeal, but we can do that. And sometimes both parties feel the need to to both ask for rehearing.
Yep.
So we might be asking for rehearing for a certain reason, but then the other party also might make the same motion based upon the different reason for something that they lost in the case. That's not too uncommon either.
Are most of the appeals filed from district court decisions by the state writ petitions versus like an appeal of a final decision at the end of a case?
Well, they would be, if we're appealing, then usually it is what we would consider mid-case in the sense that we were trying to prosecute a case and then something happened. Either a decision was made on a suppression ruling, a decision was made on dismissing charges or the entire case, and that's where we would then file something to the Supreme Court.
Interesting. Amy, what do you do in response to a state appeal?
You have to, then you then become the respondent, and you have to go through the full briefing on that. So that's happened to me twice.
And a little bit depending if it's a petition that we file,
Right.
Yeah.
again, the court gets to exercise some discretion,
Yeah.
so they could say,
So you wait.
you're just wrong. Other times they
Yeah.
say, yes, we'd like full briefing on the matter, and then we'll decide
And
on it.
that's what, I kind of get in my head about that one because on 2 of my motions to dismiss, then the state appealed me on those. So I had to go through the full briefing process on that. And my client, if you do get up to where you win on a motion to dismiss and your client is in custody, your client is entitled to be immediately released. You need to make sure that you make that motion, and because the courts and it should automatically happen, you just need to make sure that you follow through with that because the case is being dismissed. And so the state is not entitled to a stay of that judgment. It's statutory. You get to go ahead and go. And so that's how that works. But yeah, as far as like Alex is correct. If there is a petition, then you wait until the court directs you to respond, because just like if we file a writ, the court doesn't have to take that under briefing or under advisement. You wait and see. The court can certainly say like no extraordinary relief is warranted. This is something that can be addressed on the appeal.
So when a writ petition's filed, the Nevada Supreme Court will review it and tell the responding side whether or not they need to respond.
Yes.
And sometimes they just make a decision without a response.
Exactly.
Yes.
Alex, how are capital appeals different from other appeals?
As Amy said, capital is different, but what I would say is if you're watching this video, the most important thing is if you're unfamiliar with capital appeals is that you're consulting and working diligently with somebody who has
Right.
capital experience. The main thing is to review Supreme Court Rule 250. It has things that must be done in all capital cases because there is going to be, and maybe it's not official, but I would say just in general, my experience, and I think experience of everyone here, is that it's going to get a different level of review. It's the reason that you have to have 2 attorneys on a capital case. They're going to be automatically entitled to an appeal. There's going to be plenty of post-conviction work that's going to be done on it. So there are many things that need to be done in a capital appeal. A Supreme Court Rule 250 is a great start for it, but also, again, to just talk to people who really are familiar with the ins and outs of those type of appeals.
The death penalty jurisprudence is large, it is complicated, right? And there's so much to work through with it, and it's something that you don't want to go through it for the first time without having a very skilled mentor.
And Amy, can a defendant get a stay of a conviction during an appeal process?
So there are very few situations where you can kind of ask for a stay. Typically, no, you don't get a stay during that process. Death, yes, absolutely. If you can ask to be admitted to bail, to get a stay on if you are going to be sentenced to imprisonment. I don't think that I've ever had that granted. I don't know. No, typically not. What I was talking about there is you can ask that in justice court or in municipal court, you can ask that any payment of fine or your classes be stayed. In that situation, like I was talking about previously, typically they require you to post some sort of a bond, and typically that has been very high in my experience. And then if your client is sentenced to probation, you can ask that that be stayed. Usually, I have experience, I think, Deb, you would agree that it doesn't happen.
Yeah.
And Deb, what are the legal requirements to obtain a stay during an appeal?
Sure. So the very first thing that is absolutely mandatory is you have to ask for the stay first in district court. If you wait and try to do it for the first time on appeal, it's a very, very difficult road to go down. So the rule that governs this is NRAP 8, and if you didn't file a motion in district court, you're going to have to explain to the Nevada Supreme Court why filing that motion was impracticable. And the way they actually just came out with a case a couple of weeks ago, it's the TRP Fund 4 LLC versus PHH Mortgage Company. And in that case, the court said that impracticable means that you basically have to show you were not capable of filing or moving for a stay in district court. So, I mean, it's basically an impossibility standard. And so essentially, you got to ask for it in district court. I mean, you could do that orally, you can do it in a written motion, but what you're going to need to include in your motion to the Nevada Supreme Court, you're going to need to show them that you did file the stay or that it would have been impracticable, which again is almost an impossible standard to meet. You have to show your reasons and facts justifying the stay, support those reasons and facts with affidavits or sworn statements, and copies of those two things are fine, but you actually have to provide that. You need to cite to the relevant parts of the record, and you're going to have to give reasonable notice to the parties. And if the Nevada Supreme Court requires, your client might have to post a bond.
Deborah, how does bail on appeal work?
So you don't have a constitutional right. Once you've been convicted, you no longer have a constitutional right to bail as you would when you're still presumed innocent. So the right to bail on appeal is a statutory right. And both district courts and appellate courts are by statute authorized to grant bail. And they would be motions and they're allowed to grant those motions unless it appears that the appeal is frivolous or taken for delay. So unless it's very, very obvious that it's frivolous, the court can consider it. Now, the question of will they consider it and will they order bail? It's very, very, very unlikely. So there's a case called Bergna, which is a 2004 case, and the court will consider primarily whether the appellant's release poses a risk of flight or danger to the community. And again, also that factor of whether the appeal appears frivolous, because if you don't meet that first test, then the court can't even consider it. So how does that work, or how does that sort of play out? If your conviction is for a violent offense or there is a substantial sentence, then there's a really heavy burden for the defendant to be able to show that they should be entitled to bail. If the evidence of guilt is overwhelming, then it's going to be very difficult to have a bail motion granted. But if you can show that the evidence is tenuous, so maybe you have a good insufficiency of the evidence argument, or you can show that you have great legal issues, if the nature and quality of those legal issues is such that it looks like you might have a shot, you're likely going to win, then you might be able to get bail. The problem is, to be able to make those kind of showings, you almost have to wait until you filed your brief. So I've done this once in one of my cases where I had a client that was very, very adamant that he wanted me to request bail for him. And so I waited until I had the entire appellate record together. I had my opening brief, and I was able to present the court with all of the reasons in the brief why the case needed to be reversed. And I was able to make the argument that, look, this wasn't frivolous. He's got good arguments. So when you file, probably the best way to potentially win a bail motion, if you're going to be one of those rare people that actually gets it granted, do it around the time that you file your brief. And if you have good grounds in your brief and your brief looks solid, then you might have a better shot at getting it. But otherwise, it's not something that is typically granted.
And what court hears a request for bail during an appeal?
So that would be whichever court, I guess, it's in front of at the time. So they all start out at the Supreme Court, and while you're doing the briefing, I mean, it hasn't been assigned yet. So most likely it would be the Supreme Court. The clerk's office would probably route it to whoever the Chief Justice was at the time, or whoever's going to be involved in making that determination. But it would be the Supreme Court. So.
Well, thank you so much.
Thank
Thank you.